All right. A lot of people are showing up like bright and early. Let's just get it started. Um, Greetings, everyone, and welcome to the Health Justice Seminar Series, a special event series hosted by the Lancet Commission on U.S. Public Policy and Health. My name is Robert Rock, and I'm honored to be a part of the group helping to bring together these incredibly important discussions. Thank you all so much for taking the time out of your busy schedules to join us on this month's webinar. Today, our topic of discussion is titled Supreme Court versus Americans' Health. Our esteemed guest panelists will be discussing the impact of recent Supreme Court rulings on health in the United States and potential pathways forward to securing and advancing health justice in this country. Before I introduce them, we hope that everyone will use the chat to introduce yourselves and let us know where you're coming from. If you have any questions, please submit them through the Q&A option so that Ethel and I don't miss any of them when we open for questions after the initial comments. If anyone sees someone asking a question in the chat, please, Ethel will be on it, but just help them to redirect it to the Q&A section. So with that housekeeping out of the way, I'd like to introduce our panelists who will each have about 10 to 15 minutes to share their insights on the topic before we take questions from the audience and open for discussion. So our first esteemed guest is Dr. Adam Gaffney. He's an assistant professor in medicine at Harvard Medical School and a pulmonary and critical care physician at the Cambridge Health Alliance. His research focuses on health equity, disparities in care for patients with lung disease, and national health care reform. He also writes regularly for a general audience on matters of health policy and is the author of To Heal Humankind, The Right to Health in History. He is a past president of the nonprofit research and advocacy organization, Physicians for a National Health Program. Our next great panelist and guest is Dr. Linda Prine. She's a professor of family and community medicine at Mount Sinai School of Medicine in New York City. She was a co-founder of the Reproductive Health Access Project, the RAP Fellowship, and the Access List, the Reproductive Health MIG of the American Academy of Family Physicians, and the Miscarriage and Abortion Hotline. She serves on the leadership group for the MA Hotline and works as a medication abortion provider in southern New Mexico and for aid access, helping to get pills to Texas people. In all of these capacities, she has been a leader for full spectrum reproductive health care, specifically the integration of abortion, miscarriage, and contraceptive care into family medicine teaching and services. Our last, but not least, esteemed panelist is Professor Nikolas Bowie. He is the Louis D. Brandeis Professor of Law at the Harvard Law School. He is a historian who teaches courses in federal constitutional law, state constitutional law, and local government. His research focuses on critical legal histories of democracy in the United States. Professor Bowie was the 2021 recipient of the Sachs-Freud Award for Teaching Excellence for the graduating class at Harvard Law School. His scholarship has appeared in the Harvard Law Review, the Law and History Review, the Stanford Law Review, the Virginia Law Review, and the Yale Law Journal. He has also written essays for the New York Times, the Washington Post, Slate, and many other publications. In addition to teaching and writing, Professor Bowie litigates criminal and civil appeals. He is on the board of the ACLU of Massachusetts, Lawyers for Civil Rights, Mass Vote, and People's Parity Project. He is also an avid marathoner. So with that, I will cede the floor to Dr. Gaffney, and he can get us started.
Okay, good morning, everyone, or good afternoon, or good evening, depending upon where you're joining us from. So I'm going to be speaking today about some work in progress. There has been, of course, a number of Supreme Court decisions this year with very large impacts on health that have been fiercely criticized, including from the medical community, and that's why we're here today. What our group sought to do is to quantify, to project, to model the health impacts of three of these Supreme Court decisions in terms of death, in terms of health. So as I mentioned, there's really four decisions that really have been most spoken about in terms of their health impacts. There's the National Federation of Independent Business versus OSHA, which invalidated OSHA, the Occupational Safety and Health Administration, which protects workers, their COVID-19 workplace standard. There was New York State Rifle and Pistol Incorporated versus Bruen, which voided state restrictions on handgun carry. Of course, we have Dobbs versus Jackson Women's Health Organization, which overturned Roe v. Wade. Fourth and finally, there is West Virginia versus the EPA, which weakened the authority of the EPA to regulate carbon emissions. We wanted to model this scenario. This decision ultimately decided not to, given uncertainties from the Inflation Reduction Act signed into law by President Biden that created some uncertainty around the impact. So we modeled the first three decisions. So I'm going to jump right in and talk a little bit about sort of very briefly how we modeled each decision and what some of our preliminary results are. And this is work in progress, I want to emphasize. So for the first decision, the OSHA decision, background here is that OSHA was fiercely criticized during the Trump administration for not taking action on COVID-19 in terms of protecting workers. Ultimately, in November of last year, it issued its Emergency Temporary Standard, or ETS, which basically would have required vaccines or testing plus masking at businesses with more than 100 workers. And it was immediately suspended by a federal district court and then overturned by the Supreme Court on January 13th. So what we did here was we first built off OSHA's estimate that around 19 million people would have been vaccinated had that standard not been overturned. We analyzed CDC data to estimate deaths among unvaccinated, non-elderly working age adults, 18 to 64, from January to May, which is the time period when this standard would have been in place. We assume vaccines will be 85% effective in preventing death. We also modeled hospitalizations using some hospital surveillance data and extrapolating. So long and short of it, in our primary scenario, we looked at deaths, as I said, and we found that there were about 1,400 excess deaths that happened that would have been avoidable had the Supreme Court not invalidated the OSHA's ETS. And that's portrayed here in this figure, which shows weekly deaths. So during the Omicron wave, which is when there was a huge surge in deaths, both with and without the ETS in place. So many deaths would have been preventable. Obviously, many more would have still occurred. So this shows data, our estimates on the impact of the overturn or the invalidation of the ETS on hospitalizations. We estimate approximately 23,000 excess hospitalizations due to the overturn, about 3,700 ICU hospitalizations. That's where I work, and the kind of patients I've seen, about half that in terms of mechanical ventilation hospitalizations. And as I said, about 1,400 deaths. We have lower and higher bound numbers as well, I don't show, given uncertainties around certain assumptions. Okay, turning to New York State Rifle and Pistol Incorporated versus Bruen. So what this decision did was effectively find that the so-called May issue handgun concealed carry permit regulations of 6 states, as well as the District of Columbia, were in violation of the Second Amendment. And effectively, these sorts of May issue provisions give law enforcement discretion to issue or not issue carry permits. And so eliminating those provisions effectively creates what's referred to as a right to carry jurisdiction. States have tried to circumvent this right to carry standard, but they're already facing resistance in terms of court challenges. And some of them in New York, for instance, have already been overturned by a federal court. So we began by conducting a literature review and looking at how right to carry laws affect firearm homicide. And we found that looking at robust contemporary studies, a range of estimates from 3 to 9%, given some uncertainties around states' legal responses, we ultimately estimated a 4.5% increase in firearm homicide. We used CDC data on death certificates on firearm homicides for 2020 in the 7 affected jurisdictions. And then we modeled non-fatal injuries by extrapolating from some hospitalization data. So this shows our estimates of the number of expected increase in firearm-related homicides in these 7 jurisdictions. Effect would be small in Hawaii, a state with very few relative firearm homicides, and much larger, with 78 additional deaths annually in California. Altogether, approximately 150 additional firearm deaths are projected to annually to result from this decision. Similarly, we found increases in the number of non-fatal firearm injuries, as one would expect. Overall, about almost 400 such injuries, and these, of course, include very serious injuries, life-changing, spinal, cranial, thoracic, abdominal trauma, and that was what we found. So I will conclude by with the third decision. This is Dobbs versus Jackson Women's Health Organization. Of course, this is the decision that overturned Roe v. Wade and eliminated a constitutional right to an abortion in the United States, an earthquake. A decision. And so we assumed around 14 states having abortion bans in place now because of that decision. And we assumed that 11 additional states were likely to ban abortions under this decision. And so we looked at both scenarios, current bans and expected bans. So the approach is a little complicated. You might just say the number of abortions in abortion ban states go to zero. And while true, it's also true that some of these individuals will go out of state to obtain an abortion. In fact, the closest abortion provider to some people will be the closest will be across state lines. So what we did here is we built off a previous study by one of the colleagues who's involved in this project, Caitlin Myers. And in a previous work, she basically looked at how driving time to the closest abortion providers would change with and without an abortion ban. And then look at how that driving distance will impact people getting abortion based on previous work. And the kind of previous work I'm mentioning is this study, for instance, which basically looked at how SB 8, which was a Texas law that led to the closure of about half of abortion clinics in that state, how that law changed driving time for people, and how that change in driving time went on to reduce their receipt of abortion. So, relative to those who have an abortion provider nearby, those who have an abortion provider that's more than 200 miles away are 50% less likely in this study to get an abortion. The Myers approach was updated for the current study. We then used approach of another scholar to estimate the number of additional deaths because of foregone abortions. And so, we know that pregnancy and delivery carries a higher risk of death than an abortion. And so on the basis of that, you can estimate the number of additional deaths from the repeal of Roe. We also looked at the number of postpartum hemorrhages and increased morbidity from one condition whose obstetrical management is expected to change and already is changing, I should say, as a result of Dobbs. And that condition is pre-viable, premature rupture of membranes. And so I'm not an obstetrician, but this has been sort of well described, in both the literature and the news media. These are pregnant people who have very early rupture of membranes, water breaking before the time of fetal viability, and this results in a dangerous scenario for the pregnant individual. The standard of care is to offer termination as well as expectant management and leave that choice to the pregnant individual. However, what we know from Texas and the passage of their abortion ban is that no one is getting offered termination up front when they have pre-viable, premature rupture of membranes. So this was a study in Texas that found that 100% of these individuals had expectant management as opposed to initial termination, and that is associated with a significant risk to the health of the mother or the pregnant individual, with more than 50% having some complication. And there's been a lot of very heartbreaking stories about this in the media recently. Another study found that comparing expectant management versus early termination, again, much higher rates of maternal complications with expectant management, including serious things like hemorrhage and ICU care being needed. So Long and short of it, I'll wrap up in just one more minute with the results of this decision. We find that between 7 and 14 additional pregnant individuals are expected to die annually just because they're unable to get an abortion and are forced to give birth instead, which has higher risks. We found about between 800 and 1,800 additional cases of peripartum hemorrhage due to abortion bans. We found between 500 to more than 800 additional cases annually of morbidity of health complications among due to change obstetrical management of pre-viable pre-prom. So of regard to health toll, and I'll wrap it up now with a few just conclusions. So overall, we project that these 3 Supreme Court decisions will kill around 2,800 Americans over the course of a decade. We also found, as I said, many additional forms of morbidity, excess COVID hospitalizations, firearm injuries, and maternal morbidity. But I want to emphasize, I want to close by saying our approach was very conservative, and the reverberations of these decisions will be broader. OSHA decision will probably affect people beyond May. Bruen could lead to the undercutting of other gun regulations. Foregone abortions may be higher than we estimated due to provider congestion, meaning there's not enough capacity to give abortions in states that don't ban it. Forced birth, we know, increases poverty and likely domestic violence from previous work, and the management of other obstetrical conditions may change. There may even be broader ramifications from simply removing the right to bodily autonomy and privacy. So I will conclude there. Thanks everyone again, and we'll take, yeah, that's all I got.
Thank you so much, Dr. Gaffney. Very captivating, really sad data that you're sharing. I think this is a perfect segue to pass the floor over to Dr. Linda Prine to talk about a more on-the-ground and collective action approach to one of the Supreme Court decisions that you talked about. So I'll pass it to Dr. Prine. You're muted.
Thanks. Sorry, I couldn't see my screen to unmute myself once I got it all loaded up. Sorry about that. So I'm going to talk about abortion for a little bit, especially medication abortion, and then what some of the clinicians are doing as a response in order to try to expand access. Just a little background is that what we aspire to really is more than just access to abortion, but a much broader concept called reproductive justice, which is the human right to maintain personal bodily autonomy, to have children or not to have children, and to parent the children we have in safe and sustainable communities. This goal was first formulated by Sister Song about 25 years ago. And additionally, in terms of reproductive autonomy, we really want the power to freely make decisions and over matters regarding contraceptive use, pregnancy, and childbearing. These days, 88% of abortions are done in the first trimester. Hold that thought for a minute and I'll explain why that's important. As of 2020, 50% of abortions were being done by pills. So, and then just also to show you what's going on across the country, and this isn't even up to date, it's changing like as we speak. I think Ohio and Arizona have gone orange and dark red, and orange and dark red back and forth. Wisconsin should also be dark red, but it's, you know, it's a work in progress. Georgia has a 6-week ban, Florida has a 15-week ban, and then the very red states that you see here, the abortion is completely illegal. So we have about 1/3 to 1/2 of our population without any in-state access to abortion services at all. Now, that's not exactly accurate to say that there's no access, because people can get pills by mail. And I'm going to talk about that a little bit later. In terms of who could be providing abortions, it can be physicians or advanced practice clinicians like nurse practitioners, midwives, and physician's assistants. There is a subspecialty now in OBGYN of complex family planning that is not required to do most of the first trimester abortion care. And however, there are state regulations about all of this in terms of who can and who can't do abortions. Medication abortion and first trimester abortion are very safe. They do not increase any outcomes that are adverse: infertility, ectopic pregnancy, miscarriage, birth defects, or preterm births. And medication abortion is extremely safe, whether the pills are prescribed in an office and handed to the patient, whether they are bought on the internet, whether they are mailed from the doctor's office to the patient. It's all the same pill that gets swallowed by the patient, usually in her own home, with the same safe outcomes. The problem with being able to practice based on that science is that the FDA has restricted the abortion pill in ways that are not scientifically based. The pills were first approved in 2000 by the FDA, but approved with all sorts of restrictions. You can't just write a prescription for an abortion pill. You have to buy it from the company, or you have to buy it from a distributor, or you have to get it from one of 2 mail order pharmacies. And this has to be done by the prescribing person to the patient. So in order to just start doing abortions in your office, you have to have some, the permission of the administrators you work with, the nursing staff you work with, because these pills are going to either get stocked on site, or they have to be added to your formulary, or you have to add it to your electronic health record prescribing system. So a lot of people need to know that this is what you're doing. You can't just write a prescription like you would for any other new medication. And you have to sign a certain agreement form with the company that you're purchasing the pills from that says that you can accurately date pregnancies, that you can diagnose ectopic pregnancies, and that you can either provide care or refer care for complications, which is really extraordinary. There's nothing else in medicine that is actually this simple that we have to jump through these kinds of hoops for. I mean, as a primary care physician, I refer complications on all the time, right? But I don't have to sign an agreement in order to prescribe antihypertensives when I might refer my patient on for cardiac care if they have a heart attack, right? Like it's all, that's just normal medical care. So this is just one example of how extraordinarily difficult it is to do this care. Not because the medicine is complicated, but because the politics. So the common regimen that is used in the US is there's one pill of this mifepristone, and then somewhere between 6 and 72 hours, a second medication is ingested, which is called misoprostol. The mifepristone causes the pregnancy to stop growing. The patient doesn't really feel very different during the first 24 hours after ingesting this pill. It's the second medication that causes the cramping and bleeding. And it's basically exactly like a miscarriage in terms of the experience that a person has. And it's a slightly different experience if it's a 6-week pregnancy versus a 10-week pregnancy, but it's generally very tolerable with some help from ibuprofen and sometimes some anti-nausea meds. Now, what we've been doing, those of us who are telemedicine pill providers, is trying to expand access in every way we can. So the World Health Organization recently expanded the gestational age limit to 12 weeks. So many of us in the US are now prescribing the pills to 12 weeks. And that's really helpful, especially for people who are not able, people in the banned states who can't get their pills within the state. Many people are ordering them from overseas. And when they order their pills from overseas, it takes 2 to 3 weeks longer to get them. And so having an outer limit gestational age limit of 12 weeks makes it much more possible for people to get those medications. We've also followed the science and stopped doing routine sonograms for everyone. There's actually very few instances where a sonogram is really needed prior to taking the pills, so it makes telemedicine abortion much simpler. There's also been a move to use mail forwarding, so that if, say, I'm in New Mexico and I'm prescribing for patients in New Mexico, if they live in New Mexico, I can send them the pills by mail. But if they're coming to me from Texas, they have to come into the office because I can't mail pills to Texas. Well, patients are figuring out that there's ways to buy mail forwarding addresses and send that address to me. I don't know the difference. I don't know that they're not taking their pills at that address. So I mail to the mail forwarding address. The mail forwarding company forwards the pill to the patient in Texas. The only reason that I figured this out is that there was one week when 3 people were having their pills sent to the same address, and they all had different Texas exchanges. And I looked on Google Maps for the address, and it was a Staples. So Staples has a mail forwarding company called iPostal. So that's what people are using. So I stopped Googling addresses and ask no questions and forward pills, I think sometimes, clearly unbeknownst to me, but it is expanding access for people in the banned states. The organization Aid Access, as I was saying, also, with their doctor who's from the Netherlands, mails pills from overseas into all of our red states. And then the other thing that has changed that in what we're doing, those of us who are doing telemedicine abortion care, is we have been giving people extra doses of misoprostol, because when something's going on, like the person either hasn't bled enough or they're bleeding too much, this is the solution, is extra misoprostol. It cramps down the uterus and makes it bleed efficiently and stops hemorrhage and promotes the passage of the pregnancy. So we've all learned this, and the miscarriage and abortion hotline where I work that takes calls for people who are going through abortions on their own, we have started recommending this as well, and it's made a big difference in terms of not needing much less frequently. Not that it was ever frequent, but even less frequently needing to send anyone to the hospital. The benefits of the telemedicine abortion or self-managed abortion, if the people are ordering their pills from just pharmacies, is they don't have to travel to another state. The costs are way less. Like the Aid Access cost starts at $105, and they even have a sliding fee scale that goes down to $0. At most, the self-managed abortion pills ordered online are around $300, whereas the in-clinic abortion pills start around $500 to $800. It's private. Ordering your pills online, you don't have to go somewhere where anybody might see you. You can do the pills when you want to. It's not depending on being in the clinic and having somebody tell you that you need to swallow them now. And then it's very convenient both for providers and patients in terms of how we exchange information. It helps people who have to work, who work odd hours, who have trouble making it into an office at a certain time. It's much more convenient. The challenges, however, are that telemedicine abortion is legally restricted or banned altogether in 20 states. Patients do need some kind of smartphone and broadband access, internet access. Now, for people of reproductive age, that demographic generally does have phones and broadband access. Maybe 5 to 10% of people do not. It's very different from the telehealth issues that our elderly patients face. But that still can be an issue. And then one problem is that a lot of Americans don't even know about the abortion pill. So I think it's higher than 50% now. There's been so much press, but that's what it was of, pre-Dobbs. And then information is so scattered that we have people calling us on the hotline who think that abortion is already banned, people from New York or Massachusetts. And then the clinical dilemmas that we get into, you know, when you're providing remote care can be really challenging, and challenging not just medically, but sometimes morally and ethically, because you really want to tell people how to circumvent the system, and you really don't know what is legal and what isn't, because all of this is new. So I'll just leave that there. Sorry. Whoops. I want to just emphasize that pregnancy is much more dangerous than abortion. Like, the death rate from pregnancy is something like 14 times as high as from abortion. And that forcing childbirth on a family really ruins the future of that family's economic stability. I think Adam touched on some of this. And that bodily autonomy and reproductive justice have already been impossible goals for many people in our country, but particularly now in states where abortion is banned, it's just so out of reach. Other reproductive health care is also being adversely impacted, which Adam also touched on. People are not getting proper treatment for ectopic pregnancy. Infertility care has become a complex thing to do in any of these banned states, and medical training is very much being impacted. We basically are worsening our two-tiered medical care and two-tiered life, really, with these bans. So one other advocacy item that I would like to tell everybody about is doing telemedicine abortion across state lines. And Massachusetts recently passed a law to allow this to happen. And what we've done with these laws, and hope to do in New York State and California and some of the rest of the country, is to redefine the abortion telemedicine visit as occurring not in the state where the patient is located, but in the state where the provider is licensed. The whole tradition, and it's hard to even think of tradition in terms of telemedicine, since it has not really been around all that long, but it got defined as happening where the patient is located because of the insurance coverage. And when it comes to abortion, there's no insurance coverage, and there's no reason really that it should be defined as being where the patient is. It should be where the doctor's license who's doing the care is covered, right? So I should be practicing depending on my New York State or my New Mexico state license, no matter where my patient is, not based on where the patient is sitting, because I'm not licensed. I may not be licensed where they're sitting. So we're trying to get New York State to pass a law, as Massachusetts did, to say that abortion can be provided, or and also gender affirming care is part of this movement as well, can be provided according to the way our clinicians are licensed in our state to people in other states. Now, that will pit state laws against each other, and there will be legal ramifications and fights, but we need to do this if we're going to expand abortion access for people in all of these red states. So that's my talk. I just thought I'd put up a few resources about self-managed abortion, and I look forward to doing some question and answers later.
Thank you so much, Dr. Prine. Very informative and very inspiring in terms of the ways that you're thinking around this new landscape that we have to deal with. I think the legal questions in terms of states' laws competing with other state laws is a great entry point for Professor Bowie to share his thoughts on, what's going on and where we can potentially go from here.
Yes, thank you so much, and thank you for having me. I don't know if the screen is still being shared. Okay, perfect. So I'm a professor of constitutional law. I'm not a physician, but I'm here to put Dr. Gaffney and Dr. Prine's remarks in a broader political and legal context of what we can expect from the court, and also what we can do about it. So this event is co-sponsored by the Lancet, and like many Americans, I've been following British politics with a mix of smugness and awe. I watched the Queen's recent funeral with the perspective of an anthropologist by trying to identify the meaning of the various hats and the ceremony itself. And it all felt pretty foreign to me as an American. But the most exotic part of the ceremony for me was that the death of the British sovereign didn't accompany any change in government or its policies. Because as an American, I was familiar with what the public funeral of a celebrated ruler looks like. Only a few years ago in 2020, when Justice Ruth Bader Ginsburg died, her funeral also accompanied a broad public ceremony with a lot of the same attributes as in England. But where the Queen's death represented something more of a ceremonial change, Justice Ginsburg's death in 2020 inaugurated a massive change in the rights of millions of Americans. So 2.5 centuries after Americans declared independence from the British monarchy, we have somehow built a government for ourselves in which the most important national decisions are made by a group of unelected judges who serve until their death. It's a pretty odd structure for a democracy. So one broad consequence of the structure that we have in our government at the moment is that there is no guarantee of power sharing or changes on the horizon. So the last time the majority of the Supreme Court was appointed by a Democratic president was before the moon landing in 1969. Even as Democratic presidential candidates have won the popular vote in all but one election since 1992, so every election since 1992 but one, the Supreme Court has remained dominated by Republican appointees. That will likely remain true for the foreseeable future. Judges are now strategically retiring or retiring on the condition that the president respects their choice of a successor. So there's every reason to believe that the existing majority on the court will remain a majority for the foreseeable future. Another consequence of the structure that we have is that the court has used its power to undermine the powers of the rest of the government. The United States is the only country in the world that combines a national constitution that is almost impossible to amend with a national judiciary that claims the supreme power to interpret that constitution, even when it disagrees with the national legislature about what it means. So what does that mean in practice? The United States adopted its constitutional amendment to prohibit racial discrimination in voting in 1870, only after a civil war and the death of millions of people. That amendment was authored by Congress, whose members worried that it might be difficult to enforce its terms. So they added to the text of the 15th Amendment a provision declaring that Congress has the power to enact whatever legislation is appropriate to enforce the amendment. That's what's in the 15th Amendment. At various times since 1870, notably in 1965, Congress has enacted voting rights legislation to extend the franchise and protect it from racial discrimination. Yet in decisions like Shelby County versus Holder in 2013, the court has simply disagreed with Congress about what counts as appropriate legislation. It has concluded that some legislation is not appropriate, and it has refused to enforce something like the Voting Rights Act on that ground, not because of anything more complicated than its interpretation of what is and what is not appropriate. So this idea that the court has the supreme interpretive power is a concept known as judicial supremacy. Judicial supremacy is not listed in the Constitution. No one has ever voted on whether the court should exercise judicial supremacy. And a third consequence of our structure is that the court has been neglecting the power that most people think it should be exercising, which is enforcing the Constitution and federal law against state officials. So in 1871, after Congress forced through the 14th Amendment to guarantee the equal protection of the laws and the due process of laws, Congress worried that state officials would ignore these new amendments, including especially in the South. So as a consequence, Congress passed the Civil Rights Act of 1871, which instructed federal courts to go out and enforce the Constitution against reluctant or hostile state officials who might be opposed to, say, Black voting rights. At first, the court ignored this mandate completely. It not only invalidated federal voting rights laws and anti-discrimination laws, but allowed states to engage in racial segregation. But there was a period concentrated between, say, 1954 and 1973, in which the court sort of reinterpreted its role in enforcing federal law and the Constitution against state officials in cases like Brown versus Board of Education, when it prohibited racial segregation, or Roe versus Wade in 1973, in which it prohibited states from completely banning abortion, or even recently in cases like Obergefell versus Hodges, in which it prohibited states from banning same-sex marriage. All of those decisions enforced the Civil Rights Act of 1871 to require states to respect a more progressive interpretation of the Constitution. So that era has been over for some time. When I clerked on the Supreme Court in 2015, the question on everyone's mind in the building was, what does Justice Kennedy think? Because Justice Kennedy at the time was the swing vote, and so he could effectively dictate what the law would be for millions of people. But with the death of Justice Ginsburg in 2020, that era is definitively over. There is simply no reason to expect that the court will continue to enforce the Constitution against the states in a progressive direction. We heard from Dr. Gaffney about the Supreme Court's approach to gun rights and business regulations and the effect that that's going to have. We heard from Dr. Prine about the court's approach to abortion law. And there's every reason to expect that the problems they've identified will get worse. So just to take the example of telehealth abortion, the Supreme Court tomorrow could strike down the FDA's approval of mifepristone or other drugs that are involved in medication abortion. It could interpret the Constitution to permit states to ban sending abortion pills in the mail. It could make it unconstitutional for a state to adopt shield laws. It could interpret the 14th Amendment to recognize fetal personhood, making it unconstitutional for Massachusetts or New York to legalize abortion. And whatever the court does, we can expect that it will continue to do this indefinitely, because the court can predict when its members are going to retire. So even though I am a realist about this, that the problem is bad and is only going to get worse, I'm also an optimist because there is simply no requirement that Americans live under this rule of the judiciary. Rather, everything the court does, everything the federal judiciary does, is directed by statutes passed by Congress. So to give a prominent example from the past, in 1857, in Dred Scott versus Sanford, the Supreme Court famously held that Black people could never become citizens and Congress could never abolish slavery anywhere in the country. Dred Scott was the first time since Marbury versus Madison that the court invalidated an act of Congress on the ground that it disagreed with Congress's power to enact it. And the American people were shocked by this assertion of judicial power, the idea that the court could simply disagree with Congress about its role. Abraham Lincoln ran for president on a platform that repudiated Dred Scott and the Supreme Court's power. In his inaugural address, he said, "The candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal." So Lincoln's Congress responded to the court by enacting legislation that disagreed with it and regulated it. It abolished slavery in the District of Columbia and in the territories. It authorized the confiscation of enslaved people in the Confederacy. After the war, Congress extended citizenship to Black people. It enacted civil rights that gave meaning to citizenship, and it extended the franchise. When Congress was worried that the court would invalidate its new laws, Congress changed the composition of the court. It restricted the court's jurisdiction. It amended the court's procedures. It even changed the court's pension plan. And in the decades afterward, when the court started striking down labor laws or labor organizing or voter protection, Congress regulated the court's power to issue injunctions. So today's Congress retains all of those same powers. Rather than wait for the court to ban medication abortion, the American people, through Congress, can and should reassert control over the meaning of the Constitution today. With ordinary legislation, Congress can not only enact legislation like the Women's Health Protection Act, but it can also control the size of the court. It can control where the court meets and how often it meets. It can control the court's procedures for reaching decisions. And it can control the substantive standards that the court must apply to particular laws. So rather than live in the system in which our rights and powers depend on the precise timing of the death of an 87-year-old, I think we should demand of our Congress laws that will defend and protect our fundamental rights in a democracy. There's simply no other way to protect them.
Thank you so much for sharing those thoughts, that realism and those possibilities with us, Professor Bowie. Yeah, I'm still processing it all. But as we think about that, there's one question that was placed not too long ago, and it's for Dr. Prine. How is ectopic pregnancy managed in the states where abortion is totally banned?
People are being sent out of state. People are literally having to travel. Doctors are coordinating with each other from a red state into a blue state and are getting patients transported to other states.
And I can only imagine how the time crunches and the distance traveled can really impact the outcomes.
Yeah, you're only allowed to intervene when the woman's life is clearly at risk. So if somebody is already hemorrhaging from an ectopic pregnancy, then she can go to the OR and she can be treated. But you can't just give her methotrexate in advance of all that happening, knowing that it might prevent her from hemorrhaging. You have to send her to another state if you want to try and do something preventative.
And we have another question. Has anyone estimated the excess injury and death that might accompany women having to travel for abortion or ectopic pregnancy treatment?
I could respond to that. I'm not aware of that. It's a very good point. It's easy to say, well, yeah, you can drive, but there are risks and there are costs. And for that reason, a lot of people simply won't get the abortion they need. And I think one of the points I made with our projections is that they really are very narrow and conservative. As bad as the numbers sound, the reality is most likely worse, right? For the kinds of reasons you mentioned. There's travel, there's other downstream complications like increased poverty from forced birth that we did not model and we know has health impacts and can have life and death effects. So it's a good point. There's many other downstream consequences that are just hard to look at quantitatively.
And a follow-up or another question is, what about expanding the size of the Supreme Court? Like how, I guess, feasible is that? And, Professor Bowie, do you think that would be the best path forward, given, your understanding of the situation?
Sure. So I guess I would just say now, if Congress does nothing, so if there's a 2022 election that results in a Congress that can't legislate, or for whatever reason, Congress chooses not to act, what we have is a Supreme Court that has a lot of discretion, a lot of simply uninhibited discretion to do whatever it wants. If there's a regulation that it doesn't like, there are many methods by which the court can invalidate that regulation. If there's a series of state laws that it does like, there are ways in which the court can craft its interpretation of the Constitution or existing laws to protect those laws while striking down others. So we basically have a body within the federal government that has a lot of discretion to change the law in whatever direction the justices want. So from that perspective, doing nothing will allow that to continue. doing something like enacting new federal legislation like the Women's Health Protection Act or anything else, I think would represent a huge advance on the status quo. Changing the size of the Supreme Court is one thing that the Congress could do to protect something like the Women's Health Protection Act, but there are a lot of other options available. I would just say that I don't actually have a particular option in mind as the highest priority, other than a need from the medical community to recognize that any substantive goal that you might care about is subject to review by a potentially hostile judiciary. And so in thinking about crafting legislation, it has to be done with that in mind, and it has to include provisions to protect that legislation from the judiciary, because simply passing laws that are already considered to be constitutional or legal will not work.
Thank you so much for that. We have another question from Lily Armstrong. She says, I work with drug user health programs. From a legal standpoint, how concerned do pregnant people who use methadone need to be about receiving methadone out of state and related documentation / surveillance when seeking abortion care in other jurisdictions?
Very concerned. It's a mess. It's just a mess, because it's extremely hard to get something like that arranged for out of state in advance.
And then a follow-up question or request, Dr. Prine, please talk about abortion hotlines, how many need donations, et cetera, or how many are there and how many need donations, et cetera.
Well, there's a number of different services. Most of them are all volunteer. The one that I founded is a medical hotline for people who are having either an abortion or a miscarriage at home. Miscarriage care is also highly beleaguered in turn. And we founded this hotline under Trump because of how bad things were then, not even knowing that it could get so much worse. There are emotional support hotlines where people can call if they're just having a rough time making decisions about their pregnancy. Repro care is one. There are hotlines for afterwards. Exhale Pro Voice is one. There are hotlines for doula support. Repro care also offers that. So, I mean, they're all pretty findable by way of Google. And when people call our miscarriage and abortion hotline, but they really have an emotional issue or a legal issue, we refer them to our sister hotlines where that help is available. The legal hotline is called If, When, How, and they help people with all kinds of questions about whether or not what they're doing can get them in trouble.
Thank you for that. Next question is from David Chin. What are the chances of passing laws given gridlock and or constitutional amendment to limit the term of federal court judges, including Supreme Court judges, from lifetime to 10 to 20 years or mandatory retirement at 70, like in New York State?
I would say that the odds or the chances are low. So for one thing, just imagine that this Congress tomorrow passed a constitutional amendment to authorize term limits for federal judges. We would still have the Supreme Court that we currently have, and the Supreme Court has indicated a pretty profound hostility to abortion rights. And so even if we had this court for another 10 or 20 years, that's 10 or 20 years of interpreting existing law that protect abortion access very narrowly while expanding states that want to inhibit it. So as far as a long-term structural answer, maybe that would help, but that would not be my priority to enact term limits.
And a follow-up question to that, what is it to prevent the Supreme Court from declaring legislation intended to limit its jurisdiction or otherwise reform it unconstitutional?
Yeah, so that's sort of a, there's a meta question there, which is to the extent that the court is going to declare something unconstitutional, why wouldn't it declare limits on its own power unconstitutional? And I think the answer there is that historically, when there have been conflict between one branch of the federal government, Congress, and the court, Congress simply has a lot more resources at its disposal to ensure that its view governs. So just as one example, Congress controls funding decisions. And no decision of the Supreme Court could require Congress to pay for its air conditioning, to pay for its clerks, to pay for its current building, to pay for its ability, the justice's ability to take summer vacation in Europe, while striking down laws that are passed the previous spring. Congress has demonstrated that it simply has more political power than the court does. And that's what this really is. It's a question of politics, not really a question of constitutionality. I see that there's another question in the Q&A, which is why would passing legislation that would be considered constitutionally valid still be at risk from the judiciary? And the answer to that is, to the extent that we, the American people, think what is constitutional is what the judiciary says is constitutional, then the judiciary can change its mind. So what is constitutional today might not be constitutional tomorrow if the federal judiciary says, I don't know, I don't like what you have just done. But if we adopt a different attitude of what is constitutional is what we think is constitutional, the laws that we enact or the congressional statutes that we think are best interpretations of the Constitution, then what the Supreme Court says doesn't actually matter very much, because the court still needs the rest of us to enforce its decision. And to the extent that we no longer think of the court's decision as being the best interpretations of the Constitution, we don't have to follow it. And that's why I raised the example of Dred Scott in 1857, because that was a great illustration of the court saying, we're interpreting the Constitution to make it impossible to make Black people citizens. It is simply constitutionally incompatible to make Black people citizens. And Congress disagreed and said, no, we just do not respect that decision. We think we have the power to expand citizenship to everybody, and we're going to ensure that our decision is enforced using all of the tools at our disposal. We have a range of similar crises today, from abortion access and reproductive justice to climate change to gun access. And I think it demands a similar magnitude of response, as well as a different view of constitutionalism than one that simply says the Constitution is whatever the Supreme Court decides. So my priority at the moment would be, especially for an audience like this one, is demanding more from our national legislature. It's demanding one that is not simply going to punt decisions of constitutionality and legality to a court that has demonstrated its contempt for precedent and the fundamental rights that I'm sure most of the people on this call think we all should have. And so to the extent that we want to continue to see those fundamental rights respected, we must demand a Congress that is willing to legislate, even when it's risky, and even when it's politically even when it's politically risky for the members, because that's the only way these rights are actually going to be respected. It's not by just hoping that perhaps if we do nothing, we will have a better Supreme Court in the future that suddenly reappreciates the importance of Roe.
Thank you so much for that. Like, I couldn't fathom a better call to action, particularly in terms of the numbers that Dr. Gaffney shared and the stories that, Linda Prine is seeing on a day-to-day basis. And so we have 2 more minutes left, and I know that everyone's mind is just churning in terms of like, what are the possibilities? What can we do next? But I really, really encourage everyone to think about how they can help sway, create, foment political will in the way that Professor Bowie said is necessary to hold our elected officials accountable and to, take those risks that are going to protect the lives of, every single person in this country and their health. So thank you all so much for taking the time to join this talk, for sharing your ideas, for sharing your passion. And I really, from everyone at the Lancet and everyone on the planning committee, thank you so much for making the time. And I really want to make sure that everyone knows that, this is one incredible discussion out of a series, and please watch out in your emails for our next event. It's going to be on November 17th, and the topic is elections and their health implications. So again, thank you so much, Professor Bowie, Dr. Prine, Dr. Gaffney. Continuing the incredible work, and we're all, cheering for you and looking for ways that we can help support and keep advancing this mission in our respective circles of influence.